Will having a pre-existing condition hurt my personal injury case? This is a question that I get quite a bit, and especially from older clients because, almost everyone has some medical issue, especially as they get older. People are wondering, will a pre-existing condition affect your personal injury settlement? Today, we're going to talk about that topic. I'm Natalie Gerry, the principal lawyer with Gerry Law. I help injured people get the compensation they deserve for their injuries. Frequently, when we represent someone in a car accident, they may have a pre-existing condition. What is a pre-existing condition anyway? It's simply your medical history. Everyone, everyone has pre-injuries or illnesses or things that have happened to them sometime in their past. So this is a very common issue that arises. A lot of times it doesn't actually affect the case at all. If someone broke their arm 5 years ago and it healed with no issue, and then they're in a car accident, an arm doesn't necessarily affect the issue of the injuries in the present case, especially if the injuries are dealing with something like a broken ankle. If it's a completely different body part, then that is a very clear-cut argument that the injury does not affect the current status. Occasionally, though, someone has a pre-existing condition and they aggravate that condition in the accident. So, for example, they have a work injury and they hurt their back. They are getting workers' compensation and their back is improving over time, but not fully, and eventually they need surgery. So they still have pain, but it is manageable. Then say they get in a car accident, and in the accident they again injure their back. Because they have injured their back before, it doesn't mean that they don't deserve compensation for the back injury or the back injury that has made the back worse. Instead, it's my job as the lawyer to figure out how the car accident made your life worse and how it aggravated this pre-existing injury. And arguably, the accident could have even caused a worse injury because you had that pre-existing sort of weakness to the back that then the car accident has made that much worse. We do this in a couple of ways in terms of emphasizing how the accident has caused your back to be much worse. The first way is obviously by talking to you as the client and figuring out what were your symptoms before the accident and then what they are after the accident. So in this example, we could say, yes, you had a back fusion, but the pain was managed, and look at that in an objective way with medical records that would show that, hopefully. In the past, you might say that you only had to take Advil once a week when the pain was bad, and you could sleep well probably 6 out of 7 nights per week, and would wear a back brace maybe 2 or 3 times a month when the pain was particularly bad. But then you would be saying otherwise the pain was well controlled and you were able to do most activities. Then you can contrast that with after the accident. Now it's taking Advil every day because it hurts every day and constantly wearing the back brace. There may be a lot of activities that you can't do after the accident, even though you were able to do it before. So if before the accident you were able to go pick up groceries with no problem, but since the accident you have difficulty standing or walking for more than 10 or 15 minutes without a lot of pain, then that would be a big difference. You can see that the lawyer will emphasize the contrast between how you were before the accident versus how you are after the accident. So even though there was a pre-existing back condition, there is a lot of change since the accident where it's been rendered a lot worse because of that accident. Also, a specific doctrine that talks about this, and it's called in Ontario the thin skull rule, where essentially the defendant comes to the plaintiff as they find them. So if the plaintiff has a pre-existing condition that makes them particularly susceptible to a type of injury, that is not the plaintiff's fault. It is on the defendant then to compensate the plaintiff for all of the injuries that they've sustained, even if they are worse than they would have otherwise been if the plaintiff had been in perfect condition with no health issues. Even though the person is hurt worse because they have that back condition, the negligent defendant still has to pay for all of those harms and losses because the defendant caused them negligently by, say, running into the person with their car. Once we know kind of what the difference is between before versus after the accident with the pre-existing condition, then we look at other ways to substantiate it. So we'll look at the medical records primarily, and hopefully we have the medical records from before the accident to show that things were well controlled and were in a good place. And then obviously we'll get the medical records from after the accident that document the extent of the injuries and how much worse they have been made because of the accident. We would also rely heavily on witness statements from family, friends, colleagues who can talk about how the accident has affected you. So, from before the accident to after, these day-to-day observations can be really helpful to a judge or a jury in explaining how the accident has affected the person. Usually, all of this evidence together paints a very vivid picture of how the pre-accident function was versus how the after accident functioning is, and that the injury was aggravated by what happened. And these symptoms and the pain have made the person act differently and not able to do the things that they were able to do before the accident. Hope this is helpful in explaining a little bit about a pre-existing injury and how this can affect the claim for damages from an accident. If you have any questions or comments, please feel free to leave them below. And if you're interested in more legal information, please subscribe to my channel. And if you have been injured, feel free to reach out to me. If you're in Ontario, reach out for a free consultation and we can discuss your matter.